Welcome to the first in a series on the subject of access to justice and our rights as people living with disabilities in South Africa. Nothing discussed here should be construed as formal or official legal advice in any manner or form. And if you do have a matter or you are in circumstances where you believe that you require legal assistance, I would encourage you to approach an attorney or legal aid, or if you are uncertain as to what to do or where to go, feel free to contact me on Discord or on Facebook. Alternatively, I can be contacted on my email, which is coetzee.anel@gmail.com. That is coetzee.anel@gmail.com. When we think about access to justice and the rights of people living with disabilities, we are guided by legislation and other legal documents to assist us in understanding what our rights are, what we are entitled to in terms of the law, and where to go to enforce our rights and protect our interests. In this regard, the first document I refer to, and a document that probably most of us knows about, is the South African Constitution. So in terms of the Constitution, no person may be discriminated against on the basis of their disability. And we also have, amongst others, the right to equality, dignity, and freedom. These are fundamental constitutional rights that every citizen of South Africa has, but more particular for our purposes, every disabled citizen. So, in order to give effect to these constitutional rights, the Promotion of Equality and Prevention of Unfair Discrimination Act was enacted. And the aim is exactly as the title suggests, to promote equality and prevent unfair discrimination. The problem, in my view, with this act, which I'll just refer to as PAPUDA, is that, as the name suggests, in every case where discrimination is alleged, the entity that we complain about, will have the opportunity to respond to the allegation of discrimination and prove that the discrimination is not unfair. And there are various criteria on which this fairness is determined. The unfortunate reality is that if you use PAPUDA to enforce your rights, it requires that you seek relief from the Equality Court, and court action is something that we talk about a lot when we think about access to justice or protecting our rights to equality, but it is a cumbersome process for disabled people, particularly because we live in a country where we do not always have access to public transport. We might not have access to internet. We might not even have access to the technology that we require in order to access information, to educate ourselves so that we can understand the process involved, what we should do, what we shouldn't do, and so on. The other problem with the Equality Court being that when you complain about an entity and it's a large corporate entity, they'll use legal representation to prove that the discrimination is not unfair. And even if a finding is made in the disabled person's favor, at the end of the day, it still would have used a lot of your time, your resources, your energy to prove that you are entitled to something that other people are enjoying purely because they are not disabled, but you are. So the Equality Court is a measure that we can use to enforce our rights. I don't, however, know if it's really access to justice when citizens without disabilities inherently have certain experiences of equality and freedom and dignity and access, and we have to prove that we do not have the same rights in every instance. We also have the Employment Equity Act and some white papers and policy documents dealing with disability to some extent or as a whole. And lastly, we have the UN Convention on the Rights of People with Disabilities. The problem with all of these documents and legislation is that it focuses on equality, on reasonable accommodation, on discrimination, but it does not cater for the specific needs of people with disabilities. And unfortunately, we don't have a piece of legislation in South Africa catering specifically for our needs as disabled people. What this means is that because it's so broad, the legislation that we do have, we have to prove on a case-by-case basis that we are being discriminated against, that we are being denied access to justice. And because there are so many instances where this happens, we cannot be expected to really practically enforce our rights in every situation, under every circumstance. I don't think it's practical or possible. And what I mean by this is that we often complain about the same thing, but it applies to various entities like e-commerce, for example. There are numerous shopping apps that we download on our phones that are not accessible, either entirely inaccessible or partially inaccessible. And to follow the complaints procedure of every single outlet would be an enormous undertaking and a very time-consuming task. So I understand that none of what I've discussed up to this point really sounded encouraging, and the reality is that it's probably not an encouraging situation we face, but it is what we are dealing with. That is our reality, and we do have to get creative. We do have to start somewhere. So if you are not prepared to go the full legal route and fight for access to justice or try and enforce your rights as far as you can go in terms of the judicial system, it is still very important for you to document every instance of discrimination, of a lack of access to justice, of inaccessibility. The reason being that if someone else at some point decides to lay a formal complaint, to take the complaint through the legal process from start to finish. It does help if we have a record of other people who experienced the same problems. So even if you don't think it's important, even if you think that it's not worth your time, please record your complaint, write it down, leave a note about it, detailing the series of events that led up to this event, to the complaint. Leave a note about it on the Discord server, send me an email, so that we can start to build up a record of the problems we face, so that we can perhaps do something, enforce our rights, approach the entities, institute legal action, whatever it takes. There might be someone with the appetite for that. So as pessimistic as it may sound, I do think it's necessary that we adopt a culture of complaining, and that we do start to make note of the problems we face. If you, however, decide that you would like to proceed with your own complaint, it is very important to follow the legal process correctly. So what this means is that you would look at the entity or the person you would like to complain about and see whether that the company has a internal complaints procedure. So if they have an internal complaints procedure, you'd start with that. Normally it means that you have to send an email to a designated email address. You would in all likelihood get a very generic response in the lines that your complaint has been received and will be considered. You might be lucky and hear something back. You might not be lucky, but it is important to start with that first step. You could also, after you followed the complaints procedure and your complaint was not appropriately addressed, you could also try and obtain contact details of a person in a leadership or management position of that company. You could forward your complaint to that person. If that still does not change the outcome, you could approach a tribunal. So in this regard, we also have the Consumer Protection Act that attempts to provide some form of protection for people with disabilities. So if your complaint relates to any goods or services, you can complain to the Consumer of Goods and Services Ombud. So this ombudsman is a tribunal or a forum that deals specifically with consumer protection related complaints. And goods and services can really be anything. It can be very wide. It can be it can really be almost anything you can think of. And I'm not sure what their turnaround times are at the moment, but that would be a very good first step. There are other ombudsmen as well. You can, for example, approach the ombudsman for insurance. There's also one for the financial sector and various others. If that does not work and your matter is still not being attended to or addressed appropriately, you can forward or you can commence with legal action and apply to the Equality Court to have your matter decided upon. You can also complain to the Human Rights Commission if your complaint is of such a nature that it infringes on your constitutional rights to equality, dignity, or freedom. When we start the complaints procedure, it's very important to be respectful, to set out these circumstances in a logical and chronological way, and to bear in mind that whatever you do in that very first email that you write will set the tone for how the matter will be dealt with, but that might also, your very first email might also eventually go to a court and form part of a court record. And the purpose of that email is to be helpful, to give information, and to ask for relief. Moving on to something a bit more practical that we encounter in our day-to-day lives is contracts. It's important to remember that contracts can be in various forms. You can either have a written contract or a verbal contract. They are both equally important, equally capable of being enforced. The problem always with a verbal agreement is that trying to prove the terms of that verbal agreement can be tricky. So it's always better to have your agreement written down and signed by the parties. I understand that sometimes it happens that we go to a bank or a hospital, or it could really be anywhere, and you want to open an account, you want to buy something, and they put a document in front of you and they tell you, this contract just says that you'll be buying this, please sign at the bottom. In those circumstances, you don't actually know what the entire agreement entails. You don't know all the terms set out in the agreement. You do not know what obligations are placed on you in terms of that agreement. And these are all very, very important parts of an agreement, and important for you to know. It's important for you to know for how long the agreement will endure. It's important for you to know how you can terminate the agreement. It's important for you to know what obligations are placed on you in terms of the agreement. In other words, what do you have to do to fulfill your end of the bargain, to put it simply. If you do not know this and you sign that agreement, and by your conduct in the beginning, it's clear that, or it can, the view can be taken that by your conduct and by your signature, you intended to be bound to the terms of that agreement. That agreement is enforceable, and you will be held to the terms. In this particular case, it's very important to always know all the terms of your agreement, know exactly what your agreement states, why you are signing it, and make sure that you want to sign it. If there are points that you would like to try and negotiate, you are always more than welcome to do that. It might, at the end of the day, be that the entity is not willing to negotiate, and then that will be your decision to sign the agreement as is, or to approach another service provider or provider of that particular goods. So if it happens that you are somewhere and they place a document in front of you, it is well within your rights to ask for a document that is accessible for you, so that you can go through the document on your own, ask any questions you'd like to ask. or to have someone read the agreement to you if that's what you'd prefer. Please only sign agreements if you know the terms of the agreement. If you signed an agreement without knowing the terms of the agreement, it is very important to immediately thereafter contact the entity and inform them that you were not aware of the terms of the agreement, and you do not want to be bound by the agreement, and you would like to terminate the agreement. The important thing to remember when we talk about contracts is that behind every contract is value, and that value is often measured in terms of a monetary amount. So if you entered into an agreement for a 12-month period, that would mean that often prices have been determined based on a 12-month period, and there's value in that contract. So in terms of the Consumer Protection Act, if you terminated an agreement early, an entity is entitled to levy a cancellation fee. So the important thing to try and achieve when terminating an agreement is minimizing your own damages. So the sooner you inform the entity that you did not understand or did not know the terms, whatever your reason is, the easier it might be to terminate the agreement with little to no consequences for you. There are various clauses in the Consumer Protection Act, for example, that a person can use to terminate a contract. But it is also equally important to remember that if you breach an agreement wrongfully terminating the agreement or fail to meet your obligations in terms of the agreement, a company or an entity may proceed with termination in respect of your breach of that agreement. And when they do that, often that will mean that they can claim, it actually always means that they can claim damages from you, demand that you perform in terms of the agreement, and that damages is normally assessed in terms of the loss they suffered because of your termination or breach. I think the last thing I'd like to discuss is a power of attorney. So a power of attorney is a legal document that, in terms of which you authorize another person to do certain things on your behalf as if you had done those things yourself. Often you'd sign a power of attorney when you deal with attorneys. So you would give an attorney the mandate or authorize that attorney to do certain things on your behalf with the aim of managing your legal affairs, to transfer property in your name. It could also happen that you are in one country, you'd like to do something in another country, and you would sign a power of attorney authorizing someone in that country to assist you and do those things on your behalf. The problem with a power of attorney is that if you sign a power of attorney without knowing what it states, what you are authorizing someone to achieve in your name, it's very difficult to go back and say that that person wasn't authorized to do those things. So It's firstly important to know that you do not have to sign a power of attorney on the basis of your disability. There are certain instances where a power of attorney can never be accepted, such as where due to illness or certain mental disabilities, you are not capable of making decisions for yourself. In those circumstances, a curator will be appointed for you that could manage your affairs. So, blindness is definitely not a reason to sign a power of attorney. You are capable of signing your own documents, putting your own name to those documents, and making your own decisions, managing your own financial, legal, and other affairs. If you would like to sign a power of attorney, make sure that you narrow the power of attorney, the powers in terms of that power of attorney, down to exactly what it is you would like to authorize someone to do, so that it's not a general power of attorney in the sense that they can generally do anything as if you had done those things yourself. I think the last point I'd like to mention on contracts in general is that you cannot allow another person to sign an agreement on your behalf. The whole point of an agreement is that the parties to that agreement that the parties in terms of that agreement are in agreement as to the nature of the agreement, and that those specific parties sign the agreement. If a different party signs that agreement, that party is not a party to the agreement, and the signature of that person does not constitute a valid signature. You can also not allow someone else to sign a document using your signature. That is considered fraud and is also not valid. If you need to complete an agreement, you need to put your personal details or anything like that on the first page of the agreement or in some of the clauses, and it's a PDF document and you cannot do so because you can't edit the PDF with a screen reader, you are more than welcome to contact the entity or the entity that you are contracting with, and require that they provide you with a document that you can edit and complete. That might be a Word document, for example. If the entity does not want to or cannot assist you, you can also complete the agreement on a separate document where you would refer to the clause number and insert your details. You can sign it at the bottom and ask them to attach that document to the agreement as if it formed part of the agreement itself. This goes back to being reasonably accommodated. There are many other forms of access to justice apart from that which I've discussed, such as inclusive education, some parts of medical law, and I think almost every other branch of the law that you can think of might have an impact on the lives of people with disabilities. Because it's so broad, I will stop here for now. I think the only point I would still like to make is that because the legal system is of such a nature that it is difficult for us to enforce our rights, that we have to do so on a case-by-case basis, and also that there are so many instances where the same rights are being violated or infringed upon, that it becomes a difficult process to enforce those rights. We have to get creative. And one of those ways could be networking. And I think sometimes we don't always consider the power of networking and the impact that it can have, not necessarily on your life, but perhaps on someone else's life. It's important to have the conversations about our daily challenges, the things that could make our challenges easier to deal with, possible solutions, and so on, but to discuss those things with the people around us. If we can convince at least a few people to start making small changes in their daily routines to accommodate people with disabilities, we could potentially make an enormous impact on our own and other people with disabilities' lives. And by that, I mean that we might think that it's insignificant to discuss our challenges, but also the solutions to those challenges with a teacher. But we might forget that, or we might not even know that that teacher has a disabled student in her class, or that she has a disabled colleague. And this is the same for police, for doctors, for court-appointed psychologists in general. Everywhere we go, we face ignorance. And it's particularly noteworthy in respect of access to justice when we consider that if we cannot figure out how to make a police lineup accessible, or convince or educate police officers or officers of the court to communicate with people with various disabilities, then our access to justice will be denied. So in conclusion, please make a record of all your complaints. Let us know about those complaints. Give us the opportunity to try and perhaps reach out to a tribunal or a forum or a person that could assist. And remember to talk about our daily struggles, our daily challenges, but also discuss simple ways in which those challenges can be mitigated.